two matters for inclusion. The date was given today. Perhaps inadvertently it is not appearing, my lord. Let it appear any day.
What
New-
is it?
New matter, my lord. Motion
Date was given for today.
today. Inadvertently it is perhaps not appearing. Let it appear any day.
It will come
New matter, my lord. New matter.
new matter.
New matter. Motion.
Not
How
maybe
it will
permit to,
come not this side.
দুটো matter আছে।
not maybe permit to mention, my lord. I'm mentioning upon notice, my lord. My lord, the matter has been heard by your lordship, and your lordship please to direct it to appear the matter on 17th September 2025. Thereafter, my lord, the matter has not been appeared in the list, my lord. The matter is relating to the uh, benefit of the claim amount which has been, the matter is relating to the benefit of the claim amount, mediclaim amount, which has been withheld due to the fact that the petitioner did not obtain the prior permission, and the
Did not
obtain the prior permission, my lord. The short matter, any day, my lord, prior to the vacation.
not medical reimbursement. The entire amount was withheld or some part of it?
No, 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 entire amount has been withheld.
How much is it?
It is near about 5 lakh, my lord.
Not possible now in this set. It will come after the holidays. You give it, it will come after the holidays.
If any date, my lord, may be possible prior
We
to
have said then there's no point in repeating.
number one.
Lord, I appear for the petitioner, my lord. My lord, am I audible, my lord?
Yes, yes, you are out.
My lord, I appear for the petitioner. My
Yes.
lord, this is a clarificatory application I have filed.
For
My lord,
what?
my lord, your lordship has allowed my writ petitions as well as the original application filed by the tribunal in the tribunal.
Yes,
My lord, your lordship will find it. With regard to item number 1 is concerned, a CAN application has been filed by me.
yes,
There was a deduction of something of rupees 24,000 something has been deducted from my recovered, my lord, prior to my lord, the interim order passed by the learned tribunal and before your lordship, my lord.
yes.
As your lordship has allowed the entire petition, my lord, that was also in my prayer. My lord, I will be seeking only that part, my lord. Let this amount which has already been deducted to be refunded to me. My lord, this is my own sole prayer.
Serve it on the learned.
I've served, my lord. I've served upon everybody. And Mr. Prasad, I just met him in the corridors. I've served.
Let him be here. Ask him to be here.
Ask him.
Not today, ask him to be. Not today, let him be here.
Not today.
Deeply obliged, my lord. Deeply obliged.
Item 9. Item 10.
I am appearing on behalf of the petitions. Item number 10.
Second part.
Last occasion, they have taken time, my lord.
Mr. Rai is appearing, my lord. Let me analyze it.
Yes, what is the issue?
বলো, শুরু করো।
আপনি করুন।
ওই তো বললাম।
From 22/1/1982 till which date?
1982, my lord.
Till which date? Oh,
My lord, the respondent claim in way that he had initially appointed as a substitute token porter on 22 October 1981, my lord, and completed 4 months continuous service on 22nd February 1982. Before being appointed on regular measure in the capacity of Khalasi, my lord, 1st April 1986. He worked as substitute in the year 1982, 1983, 1984, and 1985. Through this way, the respondent seeks two distinct relief. First, recognition of his service period rendered as a substitute from 22nd February 1982 for the purpose of counting pensionary benefits, my lord. And second, consideration of the same period for granting MSCP in GP rupees 4,200. It has been submitted through the reply that the dispute raised by the respondent regarding working as substitute in different spells dates back to 1982, my lord, and that too without producing any credible documents in support of his claim is hopelessly barred by law of limitation. Besides, the respondent seeks two separate reliefs that fall under different rules. Violating Rule 10 of CAT Procedure Rule 1987, it is also submitted that the respondent was initially appointed as Khalasi on regular measure on 1st April 1986. During servicer period, he got 3 promotion, that is Technician Group 3 in 2002, Group 2 in 2007, and Group 1 in 2013. Therefore, the question of granting MSCP in next higher grade, that is GP of rupees 4,200, does not arise. On the flip side, my lord, the respondent passed substitute service before 1986. As per his submission in the way was not continuous and hence does not qualify for any pensionary benefits under Rule 32 of Railway Pension Rules 1993.
what is wrong with the tribunal's order? Don't read the petition. Tell us.
Yes, my lord.
Yes.
This relief was never sought by the applicant. The legal principle governing judicial relief dictate that any decision must be limited strictly to what the applicant has pleaded. My lord, my senior, my lord.
Yes. What is wrong with
What
the order?
happened, my lord? You should kindly come to tribunal's order at first.
Yes.
আমার পিঠটা দাম repeat করো। Sir, repeat করো। This is my lord, page my lord 72 onwards, my lord. I do read, my lord. That is page, my lord, 4 of the order, my lord. Para 5 and 6. Well, page 74, my lord. May I read, my lord?
Yes, we have got it.
Yes. Subsequent was 7, para 7.
When he has retired,
Yeah, probably 21 na? Superannuity annuited মানে 2015 মানে এটা কবে start করেছিল? কবে? 21 মানে 42 years back মানে। ঠিক আছে। দাঁড়াও, দাঁড়াও। This is 42 years back, my lord. That my lord, tribunals has been 82, my lord, now 2025, my lord.
so how did you establish your claim before the tribunal? How did you establish your claim before the tribunal?
But they say that they do not have the record.
How can they just see the time lapse?
But
Is it expected that after so many decades that register will still be there for you to awake from your slumber one day?
but this is the lordship has seen, my lord. I was absorbed back in 86.
See, you are claiming a benefit of a period between October to February 81. You are superannuated in 15. You have filed the OA in 25. And then you say, well, if you don't have the records, then it should be presumed in my favor.
I tell you, lordship, it is not only, my lord, my record. It is about the registrar.
Maybe.
Because
We are
they-
only concerned with your claim. We are not concerned with the others.
No, I tell you, lordship, because the rule says that these past services of those incumbents who have been working as substitute has to be maintained in a register. And
For eternity.
The rule also says that as well, permanently. May I take your lordship to those rules only? Those two,
Still, how the tribunal has allowed you to agitate the relief?
because I tell your lordship, here, my lord, I have been working, I was absorbed in 1986.
Yes.
And my lord, I was superannuated in 2015.
Yes.
Previously, it was my
So-
contract.
So my lord, my service was 29 year, 2 month and odd. So my lord, there was, my lord, shortfall of service of about eight months. So my lord, now for the purpose, the rule says that the time period which the incumbent has been serving as substitute has to be totally counted for the purpose of granting MSCP. Totally, not half, like temporary status employees. The rule, my lord, in the temporary status employees, it says the half of the service which has been performed by the temporary status, 50% of that will be counted for the purpose of giving pension or MSCP benefits. But if it is a case of substitute, 100% of that service has to be counted. So, my
The
lord,
tribunal has not gone into what you just said, that there is a requirement to keep the register forever. We
But,
don't find any such finding in the tribunal's order.
I tell your lordship, my lord, this has been, my lord, stated here because this, I tell your lordship what happens.
What has been stated?
My lord, the rule that has been annexed in the writ petition by my lord
No,
senior.
we have not gone through. It's just occurring
Yes,
to
yes.
our mind that how can it you?
Because I
Because
tell
we
you,
saw the tribunal's order, it says the
Yes.
register is not there, so therefore it will be allowed.
But
What,
I tell your lordship, here,
presumption.
my lord, here I tell your lordship, this is the rule of the railway itself, my lord, that the incumbent, my lord, who has been serving past in 1982 or whatever it is, my lord, that has to be counted in calculating the period of.
That's not the point. We don't know you were serving. There's no proof. Just
But,
because you say so, it is to be accepted.
My lord, I tell your lordship, these what happens here. But I have annexed in my original application and everything about all the receipts that I have been working as a substitute. My lord, that is there in the original application.
Nothing. Tribunal has not taken note of anything.
But in the first paragraph of the, my lord,
We are
order,
going through it.
the first paragraph, my lord, it has been stated, my lord, the period lordship will see that has been mentioned.
No, that may be, but
So that is my contention in the original application. Now, my lord,
that is your
from that,
contention. But what is the proof in support of that contention?
my lord, that I have annexed in the original application.
Nothing has been considered.
My lord, apart from that,
What is the annexure which you have placed to show that you worked from 22/10/81 till 3/3/85?
my lord, that your lordship will see page number 28 of the writ petitions.
No, but it is to be derived from the register.
Now, register, they say
The
they do
rule
not have.
says register, so these receipts will not suffice.
My lord, now I just tell your lordship two
Then the
provisions,
rule
your
is
lordship.
redundant. Anyone can come with a receipt and get it.
My lord, if I just request your lordship, only two provisions of law, if I can satisfy your lordship, only two. My lord, if I, my lord, request your lordship at first to see, my lord, page number 67 once.
No, we'll go through everything.
Oh, I'm sorry.
Your record is all the pleadings are there.
That is there, man.
Now you are
Well,
saying perhaps they have annexed something which was not before the tribunal.
One thing, my lord, was I'm not sure about which correction of my lord senior.
No, just
The
now you told
rejoinder,
us.
no, the rejoinder, my lord, that I have filed, I do not find it as a part of this this writ petition.
Why, sir?
Rejoinder, as
I'm
per
not-
my instruction, that is not
I
available. As per my instruction, that is not.
That, my lord, I
Nowhere. In the cat also it is not available. What kind of submission? Before you say something, please think out your submission before you tell us.
That you have to kindly.
We also know how to
Yes,
get.
that I. Sorry, my lord. That is not checked out by junior, my lord. It's filed.
So you complete the record.
Yes, ma'am. That is.
And if there is anything additional, you say he has brought something new on record
but I also, my lord, do not
regarding
have the copy
preservation
this.
of register. You were saying.
Yes, they have.
So therefore, you will also be required to file something.
Rejoinder,
But rejoinder, my lord, I think I have used. I'm not sure whether I have used any pleading to that effect.
No, but you are saying here they have brought it for the first time.
Oh yes, my lord, the rule.
Yes,
Rule, my lord, they have
regarding
not-
preservation of register. We have not seen. You were pointing out from somewhere.
that they have done.
So
And
then
it
you will
is
also be required to file an opposition.
I'll do that. I'll do that.
So file it.
I'll do that. But because it is a rule and that rule supports me, so I was thinking, my lord.
So if you don't want, don't file
No,
it.
no, no. I'll
No, no. It,
I'll do
as
that.
you
I
want.
need to do that because I tell your lordship, I'm not sure whether the rejoinder, my lord, deals with the document that they have annexed in the reply because I do not have this.
after 45 years,
Could it
my
be-
lord,
could it be a
anybody
lot-
can
not
come and
45 years?
claim that I am a contractual employee and then
Yes.
subsequently absorb, my lord.
Could it
That
be?
is also bad principle.
Could it
under
be?
my lord.
Could it be a lordship's pleasure, my lord, to adjourn this only? We just come back to your lordship after the vacation or whenever you're.
That's what we are doing. But is there any contempt pending?
No, my lord. Then, my lord, interim stay will be given.
No, no. If there is a contempt,
contempt.
then you will move the learned advocate for Number 11.
I have the instruction not to appear of the respondent here.
You're
Yes,
appearing for all
No, not for all.
in
One
10?
of them.
Only one.
61 respondents.
61 respondents are there. Not neither, but I have been instructed, my lord, to appear on behalf of 6% of them. Second thing, my lord, lordship will kindly see this writ petition doesn't, my lord, contain, my lord, the
That is, I was lordship. I know it doesn't contain
no
lordship,
records in the trial.
because I was going to seek a leave of your lordships to file a supplementary affidavit after the learned counsels appear.
Unless
Because
you file.
it's a voluminous OA. I didn't send 61 copies by post, lordship. So now that my learned friend is, I have craved leave.
But he is not representing.
No, that is why. He's only for 6, I know, but
So how do you get
let
over?
me prepare, then I'll give them copies. If there are, because in the before the cat, only one had appeared. All were represented by a single lawyer. Now, if there are different, lordship, still I think let me prepare a supplementary affidavit incorporating the OA and the rejoinder, lordship.
No,
I shall-
are all the original applications identical?
No, I don't. Are they all
The
identical?
original
No,
application.
lordship.
Oh, there is only one.
In one application, there are 61, 61 applicants had filed. So there was one counsel. Now, if they split up, doesn't matter still, lordship.
No,
I
they did
have
not
filed
split up. They did not receive the copies.
61. They did
61 did not receive.
No, I think
6% received and came to us.
six persons have not received, as I find, because my affidavit from the returns, it's not, service is not complete also. But I'm just seeking your lordship's.
But after you complete the service, then filing of supplementary affidavit may be better.
Lordship could grant me leave.
Because if they are, once they are here, you can hand over the copies.
That is why, lordship. That is why, if your lordship grant me leave to file a supplementary, I shall prepare it, file it, and then if there are
Then you will also be required to serve notice afresh on the non-appearing respondents.
I shall do that. I shall do that.
Therefore, we are saying you want to send the notice with the supplementary, or you want
No,
to.
lordship. the
Therefore, we are
supplementary
saying you
thing,
send a notice afresh.
I
On
shall
the
do
next
it.
date, you file a supplement.
Supplement. Yes, lordship. Lordship.
Yes.
Lordship.
You are representing.
Aside before the Honorable Supreme Court and has been decided, which I formed a part in my pleading in the region.
No, I shall give everything, lordship.
She files a supplementary now, then she will have to send it to everybody.
Yes, that is why, lordship. It was.
Great.
Then I'm not fine.
Item 12.
Hoppa niyo yaki.
Same.
Or same situation with item number 12 as.
Also, 54 applicant is there in the way.
How many? Give the
I-
file.
I will, my lord, supply the numbers. Not all. The persons who have already received
So same issue.
same issue.
12. What is the case number? 12.
03 WP CD 203.
ST.
Here, my lord, I am not given you the copy of the writ petition yet. ঠিক আছে? এটা পুরো শুক্রবার এতে কি
It's
annex
the
আছে?
same issue.
Same lot.
This is the thing, OA and supplementary affidavit and reply or rejoinder, I have craved leave. Grant us the craved supplementary affidavit.
My lord, it is again that issue of, my lord, temporary servant of the railways, whether their service as temporary employees.
Railway, এটা তো postal.
So yes,
This is also
I give
postal
it to you.
department.
where the, my lord, temporary service of those postal agents, my lord, have to be taken into consideration for the purpose of my lord, calculating the qualifying service.
Qualifying service.
It's a training poll.
My lord, this same issue was agitated before the learned Hyderabad bench of tribunal, affirmed by the honorable division bench in Telangana, and, my lord, affirmed by the honorable Supreme Court. This I already brought on record before the learned.
So you give the respondent numbers.
Yes, my lord, I'm just handing up your lordship. I'll have to check and say, because I did not have the copy of this writ petition yet.
I have already.
Just now he has been.
He will give you
Yes,
Yes, yes, he has just given.
same order.
11.
11.
I'm
13.
তাহলে পরে করো আপনি বলুন।
In this matter, Madam, Planet Additional Advocate General is appearing for the state. He is arguing in court room number 13. Well, let the matter be fixed at 2 p.m. or after vacation. Let the matter be fixed at 2 p.m. He is arguing in the court room number 13. Important matter. Huh? তো সেটা বলো তুমি করতে দেখি আমি দুটো করতে পারি এখন
Come after the holidays now.
And 14.
And item number 14, my lord,
Okay, I am appearing, Lordship. This matter, Lordship, regarding study leave. Lordship, remember the matter, Lordship. Last occasion, your Lordship heard this matter, and I am ready to forgo my salary for one.
Yes, he told us.
I was for the statement. Nato? Nato? Lordship make.
Oh yes, you were saying that you have received some instruction that they don't want to.
Release my letter. But kindly comes to page 57.
57.
Now this is the order whereby, my lord, the petitioner was granted an NOC.
No, see, the issue is he has been granted NOC, he has got admission. You are not giving him leave. He is saying, I don't want anything, I will take leave without pay. Now, wherein the rule is there is a provision that a leave without pay, you can deprive him. That is all.
It's not the issue of leave without pay, my lord.
Lordship, I am late by mistake.
That he is the head of the department.
It is an issue of leave without pay, whoever he may be.
But kindly
That's not the issue. The issue is whether you can withhold the permission or not. Whoever he may be, however important his function may be. If he wants to proceed on leave without pay, can you withhold or not? Show us from the rule. Why should we look into what is his duty and what is his responsibility?
and leave, my lord, study leave, your lordship may kindly takes up under the West Bengal Service Rules, Rule 153(1).
See, we are not on study leave. Please Don't make unnecessary submission. You said that no, he can't be released because he is doing a very important work. We ask you that he doesn't want anything for the period of his absence. Can you withhold his permission in spite of that? Now, wherein the rule is that provision which enables the authority that no, you cannot go on leave even without pay. Forget about study leave or any leave, extraordinary leave.
That even in rule 197, which my learned friend is relying upon.
197 is regarding, they are not relying upon. You are putting words in their mouth. They said, we don't want anything now.
And the difficulty is, my lord, he will be gone for a period of 1 year, my lord.
We are not concerned with difficulty. No government authority has an uncanalized power or absolute discretion to do a thing. They are bound by the rules of the service both ways, the employee and the employer. So where is the source of power? Show us. That's all.
Yes. Your lordship may kindly take up the rejection order for once.
Yes. That again you are taking us to study leave.
Kindly come to page 81 for once. Kindly, man. 87. I'm sorry, man. 87. Now, kindly consider the second last paragraph, my lord.
He again you are taking us to leave. He is on leave without pay. He doesn't want anything for the period of absence. It's not that he'll be getting a pay and he'll be studying.
That is not the issue of pay. The issue is, my lord, that the person concerned before your lordship is serving at a very
And what if he resigns today? Can you compel him? Because he's doing a very important function.
I may die even. And that is not a.
So therefore, unless there is a source of power, you have this a purely legal issue. Don't try to impress us by saying he's very important, public interest and all this. We know he's a doctor, he's required to perform. It's not that we have to be told, but whether you can withhold his permission to proceed on leave without pay. If so, where is the source of the power? That's all.
These are my written instructions. My if your lordship kindly might have a peruse, my lord. Kindly peruse, my lord. একটু স্যার মার্ক করা আছে ওই 153 তোমাকে আমি পেজ কপি পাঠিয়ে সফট কপি ঠিক আছে আমি দেখি না এই তারাগুলোতে এটা মানে ভুল প্রিন্ট হয়ে গেছে এতটা অবধি না
This does not say anything with as regards leave without pay. There's nothing in this. Let's see. And where is the order passed by the division bench of Lordship Justice Basak?
Those orders are, my lord, on facts of that particular case, my lord.
Which page?
Page 92. University. এটা তবে 2 মাস এটা কোন মামলাটা এত
চলছিল অম্বিকেশ
ম্যাডাম লেড বাই মিস্টার সেন মানে
হ্যাঁ ঠিক আছে বলো না বলো না বলো না আরে বলো না
স্যার বলেছি জজ সাহেবের বক্তব্য হচ্ছে তুমি once you have given them the NOC to participate in the counseling process, what is your power to now pass this order apart from leave?
হুম
এখানে তো আমাদের যে ইনস্ট্রাকশন আছে সেটাও স্যার ওই মানে
Yes, so this is a purely legal issue.
মাইল মাইল
Whether you have the source of power when he doesn't want anything for the period of absence, that he cannot go. He's saying he's saying that forget about study leave, extraordinary leave. I will not take any money. I'll go on leave without pay.
Now, question is, my lord, may I tell? My lord, this, my lord, suggestion has not yet been put before the authority. Before the authority, he has not prayed for this. So far, my lord, the issue before your lordship as well as before the tribunal is that whether that rejection order is, my lord, according to
No,
law.
that's not an issue anymore. That issue is changed now. He is
Now he says, no, I want leave, but without pay.
without pay. Yes.
Now the question is that, my lord, after all, the expression is leave. The effect is leave. Now, he would be the beneficiary if this is granted the leave. And the authority, the medical
So leave without
would
pay.
suffer.
Leave without pay is under which provision? That's why we are saying where is the
Here is,
source?
my lord,
Where is the source of power to
Yes.
withhold his leave even if he is proceeding on leave without pay?
well, that, my lord, I have to, my lord, find out because I have.
That is last day he submitted. We asked him. He is drawing us again and again to study leave, extraordinary leave, all these things.
লিভ চেয়েছিল সেটা দেখুন স্যার লিভ মে বি গ্রান্টেড স্যার আপনি যদি 153টা দেখেন
No, no, that is by
Chapter
general order.
15. Your lordship says, no, chapter 15.
লিভ ক্যানট বি
না সেটা বলেছে লিভ ক্যানট বি ক্লেম অ্যাজ আ রাইট কোনো প্রবলেম নেই সেটা তো ঠিক আছে সেটা তো নো কোশ্চেন
And in terms of your lordship's last order, I applied even for EOL. So that is there.
No, you are not claiming UIL. You are claiming now leave without
But
pay.
the EOL is not leave without pay. EOL, extraordinary leave, is not leave without pay.
Where is that? In
Yes, chapter 15, kindly see, Lord. Chapter 15 at page 210. If your lordship, Lord, kindly,
we will have it. We will get it.
same book.
No, we'll find it. Chapter 15.
Yes.
Leave.
That is leave.
না
Which rule?
পেজটা মিলবে
That West Bengal Service Rules Part 1.
Rule number.
রুল নাম্বার কোথায় দেখি
দুটো পাতা তুলছি
175.
175 স্যার বাদ
175
উল্টো পাল্টা বের করেছি 175 দেখো দাদা 175 বলছি যখন কি কিছু একটা আছে তো হ্যাঁ এই তো
but this was not his case.
But either or, I prayed for in my representation, Lord, if your lordship kindly sees, Lord, page 81, that is my representation in terms of your lordship's order. Lord, I specifically prayed for either EL or EOL, half pay leave, commuted leave, etc. Everything was included.
No. This extraordinary leave is totally different.
No, EOL is there. Kindly see. EOL. EL, that is earned leave, EOL, extraordinary leave, half pay leave, everything was there.
But it has not been considered yet. That is your case.
Yes.
No order has been passed.
Order has been, that is the order of rejection.
No.
Invoking 153.
No.
Invoking 153.
18/7/2025 এইটা আর রিজেকশন অর্ডারটা
Is in order. Page 87, that is the order. In terms of my representation, that is the order. Only Lord, invoking rule 153, 1 and 2. My prayer has been turned down.
আচ্ছা আমাদের 153 টা দেখি
ফ্ল্যাগ করা আছে leave cannot be claimed as of right when the exigencies of public service
এটা কি নটউইথস্ট্যান্ডিং দিয়ে বলা নেই না
Yes, yes, tell us.
My duty, my lord, to explain. My lord, so far that my lord, the 153(1) is concerned. I think, my lord, that it should be read as if that, my lord, that not standing anything because of the fact that leave cannot be claimed as a right, number one. When the exigencies of the public service so require.
In your book, is note 2 there? Is note 2 there below 153?
Yes, the government employees claim to leave is regulated by the rules in force at the time the leave is applied for and granted.
No, note 2. There is
Description should not be granted to an extent which would unduly deflate the strength of the service, yes, or departmental available for active duty. And in fact, my lord, the last line.
Yes, you have a difficulty. You read note 2 of 153.
Yes, kindly see 3, note 3.
Yes.
Applications for leave by government employees likely to revert from higher pay should always be scrutinized with special jealousy, and the leave should be granted only when very cogent reasons are adduced. It is not the intention of government, however, that leave in ordinary circumstances should be granted more sparingly. The general principle being that a government employee need not be debarred from taking the leave which he has earned at such times and for such periods as may be as may suit the exigencies of the public service.
They are invoking note 2. They are saying that the strength will be depleted. They are not on 3. They say that they cannot leave your services.
Taking analogy which has been observed by your lordship just a moment back.
No, but
if I resign,
then nobody will stop you.
If I resign, if I die, what would happen?
See, resignation is not governed by 153.
No, that's correct.
Resignation is governed by a different rule.
Leave for higher study, foregoing the salary. Can it be?
Please read note 2, what it says.
Yes. Leave of any
description.
Yes. Should not be granted to an extent which would unduly deplete the strength of a service.
So they are saying that we will be short of doctors. Now we don't know.
No, but kindly see the order. The similar reasoning was given on earlier occasions. Different petitions were moved. If I forego the salary,
they are not similar. In one case, there was an apprehension that the proceeding may be held up. So the court said, no, he will attend. In the other case, there was a issue that if it is paid, then how the recovery will be made.
Even this year, the same coordinate bench presided over by Justice Devanshu Bosak in WPST 126 of 2025 passed similar nature of order.
No, then show us. Show us.
No, it's a training result.
126, I think you have annexed it.
23.
126 is passed by His Lordship Justice Tandon.
No.
Yes.
Not by Justice Basak.
126 of 2022.
Yes.
This is 126 of 2025.
Oh. 23 also Justice Basak.
No, 126 of 23.
23 also and 25 recent this year.
All are 126. What a coincidence.
3 judgments which I find, Lord.
But these 2 don't support your case. The third one is not here.
No, questioning the foregoing of salary, that is tallying with my case. If I forego my salary,
there was no issue in those cases that he cannot be released because of shortage.
But higher study is a fundamental right.
All right.
The rule cannot abrogate the right which I have got it from the Constitution itself. The fundamental right. The ordinary rule cannot just take.
And you have no obligation. You only have rights. As a government employee, you only have fundamental rights, you don't have any
I
obligation.
have obligation not to take salary. I am not taking any salary.
That is not supported by note 2, sir. These judgment don't support your view.
But
Again, we are asking you, that judgment is not before us. If it helps you, show us, otherwise we'll proceed.
Lord, may I just draw your lordship's kind attention, Lord. Lord, regarding strength or invoking note 2, regarding dearth of doctors, Lord, I would be, Lord, drawing your lordship's kind attention. Lord, there are 4 doctors.
Professor, all are professor.
All of them are professors
Procedural.
attached to, Lord, IPGMR. So, Lord, this will not, Lord, hamper in any way. Your lordship, their factually.
That is not, that the court cannot go into.
No,
That issue court cannot go into.
But they are factually, distinguishing, and they are simply, taking. I want to study for the benefit of the government or public at large. Your lordship, kindly consider.
Again, we are asking you that third judgment, if it helps you, bring it before us, or we will proceed.
Well, that is regarding trainee reserve.
So that is under TR rules.
TR rules for 3 years.
That is a different thing.
For 3 years, Lord.
Under the TR rules, the government first takes a decision how many people they can spare.
That's correct.
Then within that quota, they allow the rule. There also, it is not that everyone who applies in TR, they will get it. We have gone through the TR rules in 1 or 2 cases. We have seen the provisions. First, they take a decision based on the cadre, how many doctors or nurses are available. It applies to nurses also.
The ground of rejection, as your lordship has seen, Lord, the ground of rejection is dearth of doctors, nothing more, nothing less. ওইগুলো দেখবেন আমি বলছি একটু ওইগুলো দেখবেন
You will have to argue with some reference to some case law.
Lord, regarding Lord, dearth of doctors, Lord, regarding resignation, Lord, your lordship has seen different judgments of this honorable court as well as Supreme Court. Lord, dearth of doctors cannot be a ground for refusal of my prayer. Lord, what would happen if I die tomorrow or today itself? What would happen? Can they take this point that the dearth of doctors, you won't be given the benefit of higher study?
In a court, we cannot compare apple with oranges. We have to compare apple with apples and oranges with oranges.
That's correct, Lord. Lord, kindly consider the note 2.
Yes.
Can it be really a hindrance for refusal?
Therefore, see, we may proceed. We are allowing
I'm
you,
just reading one second.
whether you want to argue with reference to any case law or not. Therefore, we are asking you. The issue of interpretation of 153 in reference to extraordinary leave, whether it extends to extraordinary
Your
leave.
lordship, kindly text me page 70 of my writ petition. That
Yes.
another doctor has been favored with study leave.
Yes.
Another doctor. Well, in my case, why they are standing in the way? I don't understand. Lord. Lord, in the discipline of pathology, Lord, study leave has been given. And Lord, study leave, your lordship has seen the rule where study leave cannot be denied. Lord,
Oh, where is this? Show us. Show us this line in the rule.
No. I have not completed, Lord.
Yes.
Study leave cannot be denied, Lord, without valid reason.
So where is that in the rule that you have to assign a valid reason and 153 and everything does not apply?
Lord, ওইসব নেবে না হবে পিটিশন থেকে যাবে একটু হাইপার টেকনিক Yes, cross the Lost. They say that education discharge duty there. It's a different thing. To justify payment of salary. Since you think it's salary, they say you may study, but at the same time. But if your lordship well, if your lordship from note 2, as your lordship has seen, last 4 lines, if your lordship kindly see, last,
Yes.
I'm just reading. In applying these principles, special consideration may be given to the case of government employees who applied for leave in India. So that special consideration, if your lordship really feels that I should undergo the higher studies, that can be also given to me, as a special case, special consideration be made. I am also relying on rule 2.
So extraordinary leave is leave without pay. It's the same thing.
Yes, without pay.
No.
Consideration should be read along with the first sentence.
No, we are asking you whether leave without pay is known as extraordinary leave or there is a heading of leave without pay also.
It does not appear.
No, 175, that is the extraordinary leave, but without pay. That is without pay.
That is without pay.
Yes. I applied for that also, either or.
Even that has been rejected.
Any other?
70.
And in my credit, I have also earned leave. So I'm foregoing everything.
But for a substitute for rule 153.
The allegations to the proceedings.
Exactly my speech.
Where is the rejection order?
Page 87.
87.
Yes.
Yes, maximum 3 months and 6 months in case of disease.
Yes. And 18 months is also there. 18 months.
That is for disease. That is specific. That is for disease. Once you have completed 1 year,
Yes.
you can get 6 months. But
Yes.
for disease, it is up to 18 months.
That's correct.
And that is subject to for fulfillment of the further requirement in 3A.
Right.
And for other kind of leave, you have to execute a bond under 3B. There are so many
But,
things.
I. Next page. I.
Yes.
24 months where leave is required for the purpose of prosecuting studies certified to be in the public. Well, that is definitely, I am in service of the state government. I am applying for higher study. That is for the best interest of the state.
24 months.
Government is not saying anything in my favor. The government is always acting against me.
এটা গভর্নমেন্টেরই তো পোস্ট
Right.
কন্ডাক্টেড বাই ওয়েস্ট বেঙ্গল হেলথ ইউনিভার্সিটি বলো না এটা রেকমেন্ডই তো হচ্ছে এটা তো স্টেটেরই আমি ক্লিনিক্যাল ডিউটি দেবো
That is not.
It has not, but you have not examined it in terms of 150, this 175. That's why we wanted to see the order. You have not even mentioned 175 in your order.
That I would humbly submit before your lordship that as a special case that for 1 year. I am only seeking. They can arrange. State government can arrange.
Now it is even less than 1 year. Now it is even less than 1 year. His course will be completed in April. No, come to page 87. There is no consideration of his extraordinary leave application.
There is no. But the question is whether here us under their consideration with the decision-making process they have gone into, according to them, that the dark from theory and that would not be possible even under that. That is the government mentioned, but they said that for public interest.
No, because he is
153.
extraordinary leave, there is a provision of 175 to small.
153 says that any kind of leave.
No, that's all right.
Leave cannot be claimed as of right when the exigencies of the public service. If that is my lord, at the my lord the moment it is being considered on other goods, actually my lord.
No. When his specific claim is under 175, why you should not consider under 175? Because you have taken note of the prayer dated 18/7 for grant of study leave / extraordinary leave. But you say nothing about extraordinary leave or leave of any description. So this 175 has a provision for study leave also.
There is a provision, mother, nobody can deny.
No, but then you are required to say that this is not in public interest. Have you said so? Where is that? You can, most probably you will not be in a position to deny that it is in public interest, because he is pursuing not, he will serve the government. He will have to execute a bond as required under 175.
Otherwise, I would have resigned, Lord.
Therefore,
It is for the
this
benefit.
consideration is not there. What is the course that you are trying to pursue? What is the course that you want to pursue?
ডক্টরাল সার্টিফিকেট কোর্স পিডিসিসি
Postdoctoral certificate course, PDCC.
Oh yes, PDCC of which faculty?
Discipline.
ডিসিপ্লিন রেডিওলজি
Radiology, but in my representation.
Neuro radiology.
So that is if he acquires that, now that there is, it will end in April. There is hardly any time now. So
দ্যাট ইজ অলসো গভর্নমেন্ট
The course is conducted by West Bengal Health University. That is also Lord, state.
Now it is not 1 year. Yes, then he says it will end in April.
এক বছরের course, এপ্রিল থেকে শুরু হয়েছে আমার
It's 1 year course, but he said it will end in April because the session is delayed.
Session is delayed, but I have to procure 80% percentage, Lord.
হয়ে যাবে
That would be
attendance.
So now it is not 1 year. Consider it.
That should be considered again. Then we have
পড়ে যাবে
remain either for rest of the period after.
No, the question remains, can you say that it is not in public interest? If you say that your course being conducted by the West Bengal Health University is not in public interest, then you can say so on affidavit.
Anybody wants to pursue that?
No, it's not that anyone wants to. 175. Now he is confining his claim to 175. 175, there are so many things. Some apply against him, some apply for him. So where is the consideration? But you keep considering, then his whole course will be over.
Well, Your Lordship,
But it will take some time.
Lord understands very well that I require a mandatory nature of order. Otherwise, it will be meaningless, Lord.
No, but then we cannot overlook the rule provision.
Lord, I only Lord, pray for
Everybody cannot be treated as a special case. Why you? Why not everybody who comes?
as Your Lordship has
What distinguishes you from
as
anyone
Your
else?
Lordship has observed, Lord, they have not taken into consideration the
So can
purpose of my representation.
we take into consideration instead of them?
So since Lord, the authority concerned did not
They have
take it-
failed to, therefore we should now take the decision. Whether it is in public interest, what is their policy, which courses are they considering in public interest, how do we know? We cannot. They must have made out some policy on this regard. They must have made out some policy. See, there may be a particular field where they have too many PDCCs. Then they will say it is not in public interest. We have too many. If they don't have too many PDCCs, they can't say that it is not in public interest.
Expression and rule 151. Either might have been or at the end, and notwithstanding, there is non-obstante clause was not there. But that matter when the exigencies of the public service so required, to refuse or revoke leave of any restriction is up to the authority. And these are of the appear that it is ordered with non-obstante. That means it carries with non-obstante clause. It may not be specifically there. And exactly it has been resorted to.
I leave it up to Your Lordship. Lord. Kindly consider, Lord, the situation, the being faced by the petitioner. I entirely leave it up to her. Your Lordship can very well, Lord.
No, we know our limits and we know our jurisdiction also.
No, I understand, Lord, but Your Lordship can very well, Lord. Considering the 175,
We are
considering 175(3), Lord.
yes. We cannot substitute our opinion in this case. That is the whole problem.
You're observing everything, let it be sent to the authority then. Lord. Observing everything, let it be sent. I leave it up to Your Lordship.
Very well.
May I take Your Lordship?
How soon you can take a decision?
My lord, Puja
Because-
vacation will start very recent.
Then
My lord,
lordship,
kindly
then-
consider one thing. So
Puja vacation in the High Court, not in the government.
government, High Court 1 month, but the government offices all one will be closed at least till my lord Lokhi Puja.
No, at that time, colleges will also probably not be having the course.
I think so.
I the holidays. So
Yes, yes.
some reasonable time is required.
তো কবে হচ্ছে দেখো না, একটা মোটামুটি দেখো ক্যালেন্ডারটা দেখো তো। আমাদের লক্ষ্মী পুজো কবে হচ্ছে, শেষ হচ্ছে? এখান থেকে কিছু পাচ্ছ? আমি তো কিছু বুঝতে পারছি। দেখিও না ক্যালেন্ডার, ছুটি ফুটি দেখিও না তো, দেখি পাবো না। আমাদের ক্যালেন্ডারে কিছু পাবে না, রোজ ছুটি। আমাদের ক্যালেন্ডারে কিছু পাবে না। হাইকোর্ট ক্যালেন্ডারে সবই তো লাভ। এখান থেকে দেখো। হ্যাঁ, হ্যাঁ, 15th of October, middle of October. Well, I think nothing can be done before 15th of October, middle. Non-obstante close এর মতো। Prevail, shall prevail over all. Whatever the leave rules are there. কি বলছে?
This year, the Puja holidays extending from 24th or 25th for the government. For the government, this year, Puja holidays are from
lordship 26, 26.
26th. Is it so?
Yes, lordship.
26 till
Up to
Lordship, up to 7th October. Up to 7th October.
7th.
Yes, yes. 26 September to 7th October. তারপরে খোলা। হ্যাঁ, হ্যাঁ, হ্যাঁ।
So that period your college will also not work.
they can come back with instruction that
Huh? So that means around 7th it will reopen, 7th or 8th.
7th or 8th.
See, you have 4 days this side. You take instructions.
আজকে 22।
We will not dispose of the matter.
Yes.
You take instructions in terms of rule 175. And we will give him liberty to mention before the or agitate the matter before the vacation bench. The second week he will do it. Or third week in the vacation bench.
Today is lordship 22nd. Lordship, in that case, lordship fix the matter on 24th or 25. Lordship, in the meantime, I think lordship they shall take the decision. They have the file. Everything is lordship DME. Lordship, because lordship course has already been started. This is second round decision. Highly appreciate lordship.
That's why we are not disposing of, or we
Yes,
would have
I understand,
disposed of.
sir. No, lordship, it is very difficult to. Lordship, they should come within. না না স্যার ডিওপেন স্যার দেরি হয়ে যাবে স্যার।
which date are the vacation?
What is the system when the vacation benches are available? But normally what is the?
So letting instruction.
না 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 স্যার 25-এ রাখুন না, লাস্ট দিন টপে থাক। যদি ডিসিশন আমাদের 25, Lassi, may I suggest one thing? Lassi, let the matter be fixed on 25th at the top. In the meantime, they should come. If they will be negative, Lassi, I shall tender my resignation. I shall take instruction my client that I shall not Lordship waste any time, because it is already started from April and they are so rigid. In that case, Lassi, I shall tender resignation, because I have already Lassi working from last 20 years. I will be forgo everything. But it is this course is Lassi made for the Lassi. Government has started last 2 or 3 days. Even last year also one radiologist has been accommodated study leave. I am not even Lassi bother about study leave. Yeah, when I have already forgo Lassi, they should consider this point. And Lassi, it is DME is the cadre controlling audit. It is not that Sagar Datto PG are a separate unit. Any point of time, Lassi, they can no. Lassi, I have the instruction. My client is a senior radiologist. In the Arambagh Medical College, there is one post, but they have till that they have 2 posts already there. Two doctors have there, but it is capacity is 1 post. It is very easy to for them to because DM is the cadre controlling authority to transfer anyone to Sagar Datto. No, for only for 1 year, sir. Sir, government মনে করলে সবই পারে। না স্যার এটা 30 কিলোমিটারের মধ্যে পিজিতে 4 জন আছে।
You have instructions that he wants to resign.
Yes, Lassi. In that case, Lassi, if they are so rigid, Lassi, I shall forgive everything. Because I have Lassi served from 20 years for the government. I have Lassi, it is I can say that unofficially my landed friend Lassi also don't know about the fact. So egoistic problem, because he is the HOD professor, principal also professor, Lassi. Only 2 or 3 years Lassi senior junior. Lassi, it is ego problem. That is I cannot say that, but it is Lassi, that is the fact. Lassi, they are so rigid, Lordship. And even last year also one radiologist has been accommodated, and it is government post. It is under same umbrella. It is not that I am going any other aims or any other place.
Is there any scope to perform duty there?
Yes, Lordship. The bowler has been Lordship accommodated study leave with the condition that he will be conducted clinical duty. I am also ready to conduct clinical duty, and at IPGME or PG hospital, Lordship, there are 4 professors. Anyone can be accommodated. It is within Kolkata, not that so far Lordship distance.
Right now, where are you posted?
I am posted at Sagar Datto Medical College, Lordship, Kamarhati. It is Kolkata. It is Kolkata, Belghoria. Yes, Lordship. So anybody, even I can, Lordship, go to Sagar Datto for clinical duty if occasion arise. I am ready to, Lordship. And I can Lordship clinical in any condition, Lordship. Even I can Lordship I shall pursue bond also for next 2 years. I shall do Lordship conducted duty.
Next 2 years?
Next, I shall furnish bond. If anyone has been accommodated study leave for 1 year, 2 years bond should be granted, Lordship. Record to be
That
granted.
is why we are seeing in 175 also there is a
Yes, Lordship.
there is a provision for
Kindly see page 70, Lordship. The one has been accommodated, and Lordship, even neuropathology also that subject according to their rules. I am ready.
Where is the representation that you had given after the court's order?
Lordship, that is page 81. And page 82, last line. I am also ready to furnish bond.
Where is this order passed in WPST 140 of 25?
Yes, Lordship, that is Lordship, page number 79. Paragraph 3 and 4, your Lordship's observation, Lordship. Paragraph 4, Lordship, it is not disputed that even if study leave is not granted, the petitioner would still be entitled to seek grant of other leave of his credit. That is also recorded.
So there is no direction.
Yes, Lordship, but your Lordship observation, Lordship. That's why, Lordship, I have made representation in terms of your Lordship's observation. Lordship, I want to pursue the course because it is lucrative offer. And Lordship, that's why, Lordship, I am, and why the Lordship, see, in service, being an in-service candidate, I got the opportunity.
On 22. That is also there. See, my lord. Yes. Okay. You move the vacation bench there. If there is a bench available on 16th October, by within 1 week after their government holiday, they will take a decision. And you move the government because at this time also your course is also not progressing. There is no point.
I understand your Lordship. Lordship, then time also going on, Lordship. From April 25, it
Your
started.
course will not be going on during the holidays.
Lordship,
Yes.
Lordship, I can say that, Lordship, student also will be more benefited for this. And I
Dispose করে দিচ্ছে তো।
Yeah. All right, 13th, because 14th and 16th, 2 days, we have seen there is a vacation bench, so they can move.
The petition stands disposed of.
No, we are keeping it pending,
All right.
so that you may
All right.
move the vacation bench.
Place the matter before vacation.
By 13th.
We do not know when vacation bench is there.
না, 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 দেখেছি, এই আছে, দেখা হচ্ছে।
14th and 16th, we have just seen this.
16th place করে দিতে হবে।
Lord, can it be, Lord, can it be placed, Lord, before the vacation bench, Lord, on 16th? Because this is, Lord,
Leave has been granted.
no, otherwise, Lord, listing would be a great problem. Listing in the vacation bench would be a great problem.
They will take the decision by 13th.
Yeah,
They will take the decision by 13th.
that's correct, Lord.
It will be known to you.
No,
It will be conveyed.
That
And you will
withdraw করে নাও।
know about
no,
that.
in that case, we shall
Thereafter-
withdraw. Let it be placed before the vacation bench on 16th. If we get the relief, we shall withdraw.
Otherwise, নাহলে
হ্যাঁ,
হ্যাঁ, এসে গেছে।
I don't know what is the system here, whether such orders are passed. I am not aware.
যে বেঞ্চই থাকুক, ডিভিশন বেঞ্চে যে বেঞ্চই থাকুক, তাহলে appropriate division bench. No, no,
দেখো সবাই মিলে কথা বলবো।
Of the regular bench sometimes gives liberty to mention before the vacation.
But in that case, Your Lordship, kindly give us liberty to mention before the vacation bench.
We have already
Yeah,
said that we have reached.
all right, all right.
in the meantime পোস্টটা করতে বলো দরকার
No, 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 sir.
এটা থাকতেই তো
I'm extremely grateful.
ওগুলাই আরে দাঁড়া ওইটা বলছে না
আরে
Say urgent server copy. I am praying urgent. Publish.
My lord, I'm for the petitioner item number 15, my lord. May I file the affidavit of service, my lord?
You are for the father mother.
My lord.
Yes.
My lord, there are two submissions. Absolutely divorce of the findings, my lord, this order is. And the second is, my lord, absurd reasonings, my lord. There is a void ab initio second marriage, my lord. From the dates it has been stated in the impugn order itself, my lord. And thereafter, the tribunal, my lord, the reasons to hold that the marriage is valid, if your lordship has seen it, my lord, this cannot sustain, my lord.
So who will declare the marriage to be null and void? The tribunal.
My respectful submission to it is, my lord, the second wife has come to the tribunal, my lord, for retiral benefit of my deceased son with a marriage certificate. On record, it is that the marriage has taken place before the divorce from the first wife. So there is no dispute with regard to that, my lord.
Therefore, we are asking who will declare that it is null and void? The tribunal.
My lord, civil court will declare it null and void, but by that,
Can you go for a declaration?
my lord, I cannot go for declaration.
Therefore,
but
what you cannot do in a civil court, you want to do in the tribunal.
My lord, my humble submission is, my lord, civil tribunal cannot take away my right till the date, my lord.
The question of your right. She is a valid marriage. She has given a certificate.
My lord, she is not a valid wife, my lord. It is on record. It is on record. My lord,
if on record, what is on record is there is a valid marriage, which is according to you contrary to some provisions under the Special Marriage Act.
My lord.
For that, there is a procedure prescribed under the Special Marriage Act. Without following that procedure, can any court or any forum jump to a conclusion to the contrary, or that marriage is presumed to be valid till such time a decision is taken in accordance with the provisions contained under the Act? That is the issue here.
Grateful, my lord.
So therefore, just because the facts are admitted, the marriage does not become null and void. There has to be a declaration to
my
that
lord,
effect.
but by that time, my lord, she cannot
The
be given.
tribunal has not gone on any kind of a misconception. The tribunal has said that yes, this is the timeline. Within a month after the marriage, the divorce took place. The wife, whose first wife, is not objecting. She has a certificate.
First wife has not been made party to this.
She is a wife. She is a wife in accordance with 7E of the DCRB. It has given a.
My lord, first wife has not been made party to this application.
Exactly. That's why we are saying perhaps she is not.
And I was the private respondent there, my lord. First wife, my lord, my humble submission is first wife has not been made party to this application. Second, my lord, there are three grounds on which this marriage has been held valid. One is that I was a witness to that second
wife has not come forward to claim.
My lord, first wife she might not know about this application.
We don't know. That's why we said you cannot come in the place of first one. Whatever she wants to do, she can do. It is still open to her. Point is, you have to argue for yourself.
My lord,
you cannot dispute the marriage. You cannot go for a declaration that the marriage is void. And you want that declaration through the tribunal. Can it be? That is why we are asking. It's an issue of law. The facts are admitted. The marriage precedes the divorce. There is no dispute. So therefore, what is left to argue? And the tribunal has given 1/3 of everything except for family pension. It is not that so she is getting 1/3 of the other dues, my lord, and a family pension.
My lord, I bow down what has fallen from your lordship,
And
my lord.
look at what her stand was before the tribunal. Just read it at page 3 in the bottom. We have
My
seen
lord,
it.
there cannot be an estoppel to statute, my lord. She
There
might be a
cannot be
witness.
there. That's exactly what we are saying. It has to be governed by the statute.
She
You
might
are
be a
saying
witness, but
exactly
that
what
doesn't
we
make
are.
that marriage a valid marriage.
You are saying exactly what we are saying. There is a forum for that.
My lord, but here the tribunal has held that there are three legal heirs, my lord. I'm on this ground, my lord.
Yes.
The tribunal could not have hold, my lord, that there are three legal heirs because the tribunal in its finding has held that the marriage, second marriage has taken place before the divorce of the first marriage. Second ground, my lord, that there was no departmental proceeding conducted against the deceased employee, my lord. And third, what my learned senior friend has submitted, my lord, that I was a witness to the second marriage, my lord. So on these three grounds, the tribunal has held that this marriage is a legal marriage, my lord, marriage,
No,
and that is
no,
why.
no. On the basis of certificate that you are overlooking.
My lord, basis of
certificate issued by competent authorities, certificate corroborating the marriage which was performed, that also has been produced.
Produced, my lord.
And who are you? That's why we are asking to dispute
lord,
the marriage.
My lord, kindly appreciate, my lord. If this marriage is declared null and void, my lord,
Exactly.
then in that case, my lord,
Exactly.
the entire share will come to me, my lord.
Exactly. You are correct. That's what we are saying. Once it is declared null and void, you may not get anything. We don't know whether the first wife will share with you or not.
My lord, that is a different question, my lord.
So therefore, once it is declared null and void, that is the bottom line.
My lord, so even I have a right to go, my lord, to the tribunal, civil court, my lord.
We don't know. That's
because
not
of this
before us.
because this is of the retirement benefit, my lord, it will be shared among the legal heirs only.
May be a party to the succession certificate case, but whether you can go to the court for declaration of the marriage to be null and void, we have some doubt in that.
My lord, succession heirs, my lord, can be declared that I am only the
Succession
legal.
certificate has already, perhaps that would not result in anything more. At best, you will get 1/3. Even if you go for a succession certificate, you will not get more than 1/3. Both of you, in fact, together you get 2/3 and she gets only 1/3. And she has taken that stand before the tribunal that I want them to get their share. No, but pension she is getting full. So that is probably where the shoe is pinching.
My lord.
That she is getting the entire pension.
That is not the question here. Whether I am pension holder or not, my lord.
How do you know?
I was the wife, my lord.
Is there any material before the tribunal?
The RBI. No.
They were employees. So
The RBI. Both of them. Both of them.
My lord, that instruction I don't have.
Witness cannot deny that. They are employees of the RBI.
find out.
My lord, I'll come back then, my lord.
It is after some argument. Yes. It can always be apportioned if required. And 1 month.
Madam 16.
Lord, I am for the petitioner. May I file affidavit of service? Lord, impugn order, my lord, at page 105. Yeah.
What is the decision in the case of Purnima Das?
My lord, if your lordship, yes, my lord.
That married daughter will get.
But I have only one copy, my lord. I am extremely sorry.
What is it? Just tell us.
Yes, my lord. Your lordship kindly see.
Tell us what the decision is.
Yes. My lord, married daughter is entitled for compensatory appointment, and my lord, he is a daughter.
And what is the date of that decision?
My lord, the decision is, my lord, it is 2017, my lord, SCC online, Calcutta 13121.
What is the date of the judgment we are asking? It must be there.
13 September 2017. 13 September, yes. 20 September. But if your lordship kindly takes page, my lord, the 74, 75, 88. Oh, I'm sorry, my lord. Lord, prior to that, if your lordship kindly turns to page, yes, page 63, my lord, previous order of this honorable court, my lord.
And when was you made a claim? It was rejected.
Yes, my lord, I actually make an application for compensatory appointment.
What is the date of rejection?
My lord, rejection, my lord, that is the
2014.
Yes, 2014. At that point of time, my lord, just my lord, 2 years I have got married and my father has died, and I was totally my mother and I am the only legal heirs.
You applied or your mother applied?
Yes, and mother also consented me, my lord, the no objection in my application. My lord, if your lordship kindly turns to page.
What was the age of your mother at the time of death of the employee?
My lord, over 50.
So she was ineligible.
Yes.
Then why did you wait more than a decade to approach the tribunal?
No, my lord, there are several proceedings, my lord. If your lordship kindly see the first, my lord, the first application was 31st January 2014. My first application before the, my lord, the Deputy Commissioner of Police, that was rejected. Then, my lord, the further application was made on 31st January 2018.
After one application is rejected, where is the question of making any other application? That is what we are asking you.
No, my lord, there is an order of this honorable court also. My lord, if your lordship kindly see page 63.
No. This is of 24. What are you saying? This 10 years after that rejection.
No, my lord, the department intimated me, my lord, on 31st January 2018. I made a, my lord, kindly turns to page 27. My application, my lord. But the first rejection on the ground that I got married. Then, my lord, the 31st January 2018, my lord, the mother of the petitioner, my lord, that is in page 28.
Therefore, we are saying once it is rejected, where is the occasion of making representation after representation? Therefore, we said, why did you wait for a decade? You couldn't, you can still make representation. Why did you come in 24? You could have made representation till 25. Why did you come in 24?
My instruction is that department, my lord, intimate to me that we are in the process. You will get.
Where is that intimation?
My lord, that intimation, my lord.
Where have you said in the OA? Show us from your OA that you have said this.
No, my lord, that not in the.
Then we will not take cognizance of
right,
such,
absolutely
such
correct.
things.
Absolutely correct. My lord, kindly turns to page 26, my lord. That was the first application. Page 26.
That is over in 2014.
Yes.
So why after a decade? That is the issue. Forget about whether that judgment has retrospective effect or prospective effect.
There are so many difficulties.
How can you come after a decade before the tribunal?
No, leave was granted. By that order, my lord, the leave was granted to go before the department. My lord, kindly see that order, page 63, my lord. Leave was granted to the petitioner. My lord, kindly see. My lord, page 65, yes. My lord, page 4, my lord, accordingly, the writ petition is disposed of with liberty to the petitioner to file an appropriate application for the compassionate appointment before the competent authority, being the Secretary, Department of Home, within a period of 3 weeks from the date. Upon receipt of such application, the Secretary, Department of Home, West Bengal, or his delegate shall consider the petitioner's claim upon granting an opportunity to the petitioner and pass a reasoned order in accordance with law and communicate the same to the petitioner. Then, my lord, we made the representation. Then again, my lord, that was rejected. We filed an way also rejected. Then we went to tribunal. And ultimately, my lord, the 19th June, the order was passed.
Where is the judgment in Purnima Das?
Extremely sorry. Today I have got only one copy.
2 copies.
Lord, your lordships, kindly keep this tomorrow, my lord. Kindly keep this tomorrow.
What is the decision?
Primadas merely says that to make married daughters ineligible from a scheme of compassionate appointment is not constitutionally valid. It makes married daughters also eligible, but it does not say that married daughters, whether dependent or not, will be eligible. The dependency, the financial stringency, the penury, all other things remain the same. Only the blanket exclusion of married daughters, the 3-judge bench says that it's constitutionally invalid.
So but they become like any other beneficiary under the scheme.
Right. So, Malad, but in this case, the government decisions or the tribunal decision is not on the ground that she is a married daughter. It is on the ground that the husband is having a monthly salary of 70,000.
No, but there is a requirement under the scheme that the eligibility is to be assessed by a 3-member committee.
Right.
So where is that assessment?
Malad, this, if your lordship kindly sees the impugned order, Malad, there is an admission that the husband's salary is 70,000. And the applicant,
as on date, Malad, not at the time of. Yes, I'm sorry. I'm sorry.
Which is the deceased daughter, is also a practicing advocate.
No, that is immaterial.
Who is Malad?
Who is what is not material? And material is that there is a procedure prescribed for going into the issue of stringency. Unless that procedure is followed, how a decision can be taken?
Because my lord,
Just because she's an advocate or she's something that will not
same order,
suffice.
my lord, the same order which my learned friend relies on to cover this period of 10 years and to say that liberty was given to me. My lord, that same order says the decision to be carried out in a particular manner. If your lordship takes page 66.
Yes, we are looking at page 66.
Second paragraph.
Yes.
It gives them the liberty and the competent authority, the secretary, to decide the matter within a period of 3 weeks.
Yes.
So the secretary hears the matter. Secretary takes the facts on record, considers the facts within.
There is an order passed by him.
Yes.
Where
That is at page 68.
Oh, that is the order before the tribunal.
Yes, that was the impugned order before the tribunal. There your lordships will find in the second page, few things are recorded. But there's there on the 68 also, but 69 is more important. Page 69, point number 7. And thereafter the heading findings. Now, may I place it, Malak? Point number 7. Sri Obijit Chatterjee, husband of the applicant, is presently working as assistant teacher in government-aided school with effect from 2008, and gross salary of her husband for the month of September 2024 is 70,052 rupees. Then, Malak, can you take the finding? The applicant so-and-so is, though eligible to apply for compassionate appointment in terms of Labour Department's memo number so-and-so, whereby the provision married daughter, including legally adopted daughter, before death or incapacitation or missing, is included in clause 3C in its earlier notification dated so-and-so, but she herself being enrolled in the legal profession as an advocate and her husband having earning of a hefty gross salary of 70,000 per month, there appears to be no need for financial assistance to the applicant or the family of the deceased by way of providing compassionate appointment. Then kindly skips over the two judgments referred. Then C. From the guidelines relating to compassionate appointment issued by the Labour Department and from the judgments of the Honorable High Court referred above, it is clear that the concept of compassionate appointment largely relates to the need for immediate financial assistance, not after 11 years. And one more thing, if I may point out, they have made out this entire case in the WPST.
Yes.
That I was not residing with my husband but residing with my mother. Kindly takes page 5, paragraph 5 of the WPST. Though they have made out that ground in the grounds, kindly sees the pleading. The pleadings militates against their ground. Page 5, paragraph 5
of the OA
of the WPST. On the basis of which they have come before your lordship. Their main ground is that I was living with my mother, not with my husband, so I am dependent. Kindly see paragraph 5. And is staying with her husband. And then the ground is that I am not staying with her, my husband, so the tribunal's order is bad. And then paragraph 7 also kindly reads. 6 and 7. She used to attend the parental house. গ্রাউন্ডটা বার কর WPST গ্রাউন্ডটা বার কর যেখানে লিখেছে আই এম নট স্টেইং উইথ মাই হাজবেন্ড তাহলে ওকে বার করতে তুই তো পেয়েই যাবে মাথা কাটা কত জাজমেন্টটা কত আছে গ্রাউন্ড খুঁজে পাচ্ছিস না পিটিশনে
first day before the tribunal.
My lord,
it has been disposed of on the first day or your reply was filed?
No, nothing was filed, my lord.
Then you file.
Was taken up on 23rd November.
Then you file a reply, we'll consider it. Let opposition affidavit
Judgment, Madhya Pradesh judgment, the Honorable Court of the Madhya Pradesh High Court.
Item 17. Item 17, my lord, I appeal for the petitioner, my lord. My lord, this is an application where a doctor tendered her resignation. Now, my lord, what has happened in this case, my lord? The authorities have not clear-cut said that rejection order, but if your lordship takes up a show cause notice, which was issued by the authorities, which is appearing at page, my lord, page 52. Page 52 of the writ petition, my lord, your lordship will find the tenor by which the show cause notice was issued. It speaks of, my lord, rejection. Your lordship, kindly have a look, my lord, page 52. You are hereby directed to join your normal duty within 3 days of issue of this letter as per the directions given by the higher authority. Your lordship has got it, my lord. From Shasto Bhavan. If you fail to join within this stipulated time, appropriate action may be taken against you as per West Bengal service rules. Now, my lord, this being the situation, my lord, I, my lord, replied to the show cause and, my lord, moved the learned tribunal. Now, my lord, as because the learned tribunal is not functioning with any of the members, my lord, matter is fixed before the my lord, fixed before the registrar bench on 12th of January 2026. Now, my lord, I am also covered by your lordship decision, my lord, which was annexed in the writ petition and in the original application, my lord. And this issue, I may say, my subject lordship kindly has now more or less been settled by your lordships. I fail to understand why they are still bent upon or insisting upon such thing, my lord.
Yes, sir. Page 57, sir. Judgment. Page 57. Yes, sir. এই কোর্টেরই
So this resignation is under which provision?
My lord, Rule 34, my lord, is a resignation simpliciter. My lord, there is nothing I be seeking, if lordship
No,
takes
there is a provision that it automatically takes effect.
My lord, yes, sir. My lord, the note to the rule says, my lord, if your lordship, allows me to go through the note, my note says a time is if given, my lord, and my lord, that becomes after
Which
the
rule you said? Which rule?
Rule 34, my lord, 1A
Of
the WBSR Part 1. Now, if your lordship takes up, my lord, Rule 34A, my lord, 1 note I.
Yes, sir. Part 1.
It is also quoted in your lordship's order, page 61.
Yes, my lord, your lordship has elaborately dealt with the provisions, my lord.
ওটা স্যার ইমেল 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 হ্যাঁ
এখন দেখাচ্ছি
হ্যাঁ সাইড থেকে একটু নেগেটিভ আসছে
We have to decide the same thing for everyone.
In this case, my lord, it appears that that particular prayer or my lord representation not yet considered. No order has yet been passed, except that my lord, I just received my lord my instruction that such and such thing that the application or resignation letter that was not through proper channel, not within the period which is to be given, the maximum period of at least 3 months. But it appears that that particular consideration has not yet been made. So I think authority, let them take a decision. Let them take a decision, my lord, pointing that whether they decide in favor or against, let there be a reason. My instruction is something else, but my humble submission that I received this instruction is. And it appears that something is there with regard to their mother taking note of it. But my humble submission, I direct the authority to consider that within a specific period, pass a recent order.
Please see what is the rule.
Because I received it only today.
So what are you to get anything after the resignation?
No, my lord, 7 except GPF and GIS, which is my money. 7 except that I won't be getting anything.
So if that is given after some time, that will not matter much.
No, my lord, the problem is this, my lord, the impugn notice, which is there, my lord, that indicates, my lord, they have taken decision.
Notice, we are asking you whether the dues anything apart from group insurance and GPF.
No, my lord, I will be getting nothing, my lord.
Let them take it.
Yeah.
Where is the judgment that we had passed in the other case?
Yes, my lord, your lordship will find it is also annexed to the writ petition. Right, it starts from page 57, your lordship's order. Page 57 of the writ petition, my lord.
There it was a reason order, challenge that reason order. Here there is no reason order.
No, my lord, in that case also no reason order was passed. Ultimately, your lordship has held the order which is purported order of the principal secretary is non-est in the eye of law.
I said so.
স্যার কোর্টে স্যার ধরিয়েছিল হাতে হাতে ওটা সাইন ছিল না এটা উল্লেখ আছে
30 months.
Is this to facilitate any other employment, your
No, my
resignation?
lord, I will be pursuing, my lord, my own career. My daughter is there, my lord. She is studying abroad, out of state, my lord. I want to, my lord, join her. My lord, this is my basic problem. She is pursuing MD course, my lord, MBBS course.
We have recorded specific finding that you cannot do this. Once notice given, nothing can be done. Where's the question of passing any order? That is the decision, and we have said this is the fifth decision.
I have gone through, but so far the facts, that the judgment relied upon and annexed to
There the facts are different. The purpose of putting resignation, purpose was different.
So therefore, that gives any difference to your power? Whatever may be the purpose, whether he wants to go and sleep at home or he join, what difference it makes to you?
The balance of convenience, inconvenience also tilt in our favor with regard to the service of the medical service.
Are you serious? You want to raise these issues after going through this order?
Very difficult. Very difficult. I can say
Therefore,
all
yes.
these things. Very difficult. Yes.
Do something in a.
My lord, if your lordship kindly have a look, my lord, on the last occasion also, so far the other matters are concerned, the learned advocate general, my lord, placed the instruction.
In this case, he had appeared. In this case, he had appeared.
Yes, sir.
Yes.
The case that
I have seen. I have
yes,
seen, I have seen, and then
yes.
the Lord Advocate General, my lord, placed the instruction. If your lordship kindly allow me, my lord, since no order has been passed, instruction is
So no order has been passed. That we appreciate.
passed,
But we have said once notice is given, nothing is to be done
uh,
because they will get nothing from you.
so far the notice point is concerned. That is also, my lord, it has been, my lord, taken note of the notice point, and it appears that the prescribed period has not been followed.
More than
point, my lord can say that from the date of the putting of that until date.
in fact, he has said that from 31st August, don't pay me salary also.
At least
He is requesting you not to pay her salary.
Here the point that is being taken also, that at least 3 months notice should be given, and that has not been done.
3 months. Where is the 3 month?
1 month, and then if lien, then 3 months.
1 month.
1 month, and then if lien, then 3 months.
This is a question of 1 month only.
A and then B.
This is 1 month. This is not 3 months.
34A1, then small a, then small b. I do not know whether holding lien or suspended lien is applicable in this case or not. But
When does the notice period lapse?
My lord, 31st of July was the last date. 1st of August, it takes effect, my lord.
No, how long notice have you given? 1 or 3 months?
My 1 month and few days, 12, 13 days. Now, my lord, even the rule says, my lord, if there is a shortfall of notice, my lord, I'm not saying this matter. Only thing they can do, my lord, they can ask for the leave of shortfall money.
That we have considered also.
And my lord, that is your lordship's order is also there, my lord. And I
Yes,
also
that
in
we have
resignation
considered.
mentioned.
That also does not help you. You take instruction from the authority, come back on Thursday. Get it over. Yes. On being faced with the
Deep obligation.
right.
May I please, Your Lordship? My lord, I'm for the petitioner, with Your Lordship. My lord, since my lord, the tribunal is not functioning for want of bench, Your Lordship, Lord, the matter was referred for hearing in the month of January. So we moved before this honorable court, Your Lordship, challenging the order impugned, wherein, my lord, the state has refused my prayer for study leave, Your Lordship. This is the second round of litigation. My lord, the petitioner, as a pharmacist, Group 3, Your Lordship, holding a degree of diploma in pharmacy, he intended to study, Your Lordship, Bachelor of Pharmacy. Accordingly, a joint entrance examination was held by respondent number 415. He passed there. Thereafter, my lord, counseling was done, and in the counseling, he was provisional allotment was given. He got himself admitted in a school, Your Lordship, in a college. And in the meantime, Your Lordship, prior thereto, my lord, prior to sitting in the exam, Your Lordship, he made an application before the authority for seeking leave, my lord, to appear in the examination. And subsequently, Your Lordship, after passing the examination, Your Lordship, and after the allotment of seat, Your Lordship, he made an application for study leave. My lord, the study leave, my lord, that is at page, Your Lordship, page 68 of the application. My lord, kindly take, Your Lordship, page 68. It's a detailed representations being made, Your Lordship, wherein it has been specifically stated that his whole intention, Your Lordship, that to go for higher studies. The reason was given. My lord, rejection, my lord, the initial rejection, Your Lordship, at page 118. My lord, that was set aside by the order of the learned tribunal, and that is at page 20. And the tribunal, honorable tribunal, directed the respondents to reconsider the representations of the petitioner, and by order impugned dated 120, that is at page 123. Once again, the application of the petitioner was rejected. At page 123, it starts from page 124. And the first order of rejection, Your Lordship, is at page 118. It's a cryptic order. Nothing's being stated. That order was set aside by the Honorable Tribunal. The order is that at page 120. An Honorable Tribunal, after setting aside the said order, directed the respondents to reconsider the case of the petitioner. And this, by order impugned, Your Lordship, this order was passed.
Your OA is at which page? OA is at which page?
Pardon, Your
Your OA.
Yes, Your Lordship.
Which page?
OA, my lord, starts, my lord, from page 27, 26. The entire application I have annexed. Page 26.
File your opposition.
My lord,
same order. Tell him the date. Inform the date. 19.
Right, Lordship.
Yes, my lord, I appear on behalf of the petitioner, my lord. My lord, the issue remains, my lord, I am the employee of a consumer affairs department. My lord, I was posted initially in Malda. Subsequently, my lord, I have been issued a transfer order, my lord, to report to Chachol. My lord, at page, my lord, if your lordship kindly sees the page 28 once. Page 28. My lord has got it. Page 28. My lord has got it. Page 28, 4th March 2025, the Assistant Director, Consumer Affairs Department issued a memorandum, my lord, where, my lord, I have been transferred. And I have been released. Pursuant to that particular memorandum, my lord, I went to join to the Chachal.
Application, explanation.
Explanation.
Why should you not submit an explanation? Why?
My lord, the issue remains, my lord, if your lordship kindly sees, I have submitted first.
So why can't you say this to them? Why the tribunal or the court has to come in at this point when they say you go and join?
I went to
say
join.
you have joined, they say no. They
No,
say
my lord, the issue remains. May I submit?
Please come to page 44.
My lord, my lord.
Yes.
Yes. My lord, as per the order dated so and so,
This is the impugned order before the tribunal.
My lord.
So what is wrong with this order?
My lord, the issue remains, my lord, my salary has been stopped.
What is wrong with this order?
But the
We cannot go into your entire service here. This is the issue before the tribunal.
My lord,
Whether this order is illegal. Why? Tell us.
That is, my lord, at page, my lord, I have already submitted before them. That is, my lord, at page, my lord, page
So
29.
you could have responded that I've already submitted an explanation. Why not? Who is stopping you from saying that I've already submitted an application? Please find it on such and such date.
Page
I have given
29, my lord, I have submitted.
We don't know.
My lord, that is, my lord, within the record.
We are not going to see it. Why can't you tell them? This kind of a letter you are challenging before the tribunal.
Yes,
they are
my lord,
asking for an explanation. You say don't ask for
Because,
explanation.
my lord, it says that as you have reported to the higher authority, for such reason, my lord, it cannot be.
So?
Because there is no reporting authority at all.
So, why can't you respond? We don't know. We can't presuppose that as a result of the reply, something very bad will happen or something very good will happen. We don't know. You are coming to the tribunal with such an order. Nothing is there. How anyone can be aggrieved by a letter asking you to explain why you have not joined? It's not even a charge memo.
My lord, I have already, I have explained it.
We don't know.
Page 29,
We
my lord, if
will
your
not
lordship
look
kindly
into
sees
it.
once.
We will not look into it.
Page 29, my lord, subject to my satisfaction, my lord, if your lordship kindly sees that.
We are only concerned with this letter. What is the infirmity? It is in contravention of which rule provision? What is the illegality? That is all.
My lord, it says
your employer says that you have not joined on such and such date. Please
I have joined.
So tell them.
I have joined.
Why can't you tell them?
I have joined. The issue.
Why can't you tell them? That is the issue. The issue is not whether you may not join. You may say I have not joined because of this problem.
Joined. I have accepted.
No, there may be a problem which is beyond your control, and you may tell them that look, for such and such reason I have not joined. It's not required that you have to join.
No,
But
my lord,
then
I have
this is the
accepted. My lord, once I have accepted, I cannot deny it that I have not joined.
Therefore, we are saying this explanation, seeking of explanation, does not close either option to join or not to join. If you have valid reasons, you will tell them for these valid reasons I could not join. And if you don't have valid reasons, you will join and say that yes, I am joining. Or if you have joined, you will say that I have already joined. Why tribunal and high court against this letter? Why?
My lord, one paragraph, my lord, if your lordship kindly sees in this particular memo, if your lordship kindly allows me. Thirdly, you have directly approached and informed in written version about your queries to the Deputy Secretary, Consumer Affairs Department, Government of without moving through proper channel. They are saying this thing, this particular, my lord, when I have been issued a so cause, my lord, I have a right to join there in the transport post. I went there. I have joined there. Subsequently, my lord, I have to report to my higher authority. Higher authority was on leave, and subsequently there is a transfer memo. And till date, my lord, he has not joined the hierarchy. Where do I report? My lord, that is at page 29, if your lordship kindly sees. Once I have indicated the same. There is no reporting authority. That is the problem.
Take down. Heard learned advocate for the
Initially,
Yes.
item number 38, 30 and 31 was tagged with item number 30 and 31, which has been fixed today at 2 p.m. for hearing. My lord, if any or I humbly pray before my lord, kindly take up this matter with those two matters, since issue is same and subject matter of challenge.
When it is called, you be here. When those matters are called, you be here.
ডাকবে তখন বলতে বলছি।
ওই 30 আর 31 এর সঙ্গে 2 PM at item number 20.
We are for the petition.
Oh, that orders matter. The application is dismissed. Grateful.
My lord, then my lord, if your lordship is dismissing it, my lord, one prayer may I do? My lord, it is
After
only-
dismissal.
My lord, can 4 is dismissed only because can
Yes,
4
yes.
and my lord, that my lord, one further prayer, my lord, that let my lord status quo be maintained
Sorry.
because my lord, that no.
Can 4 has nothing to do with status.
No, my lord, one thing, my lord, because tomorrow, my lord, public possibility, my lord, that under the PP Act.
We have passed the
Public
order,
Act,
sir.
but my lord, that my lord, let it be recorded that I pray for my lord that the status quo or the stay, but
Status
which
quo
has
for
been
what?
refused.
What is status quo?
My lord, that is you
There
have
is no such prayer in the.
but
It
my
is
lord,
only
yes,
for.
it is true. But my
At
lord,
this juncture, the learned advocate
yes.
for.
My lord, have I, my lord, that
Next.
will I be able to?
No, you will get it after some time. Just wait. We will just go through once we have just signed it. We have not read it full. There may be some corrections. And plus we have to incorporate what you have just submitted. That has to be added.
My lord, that because Amjad Ali Sardar is also there and he has been now in courtroom number 8 in an urgent matter. Sardar Amjad Ali.
No problem. He has made all the submission. Yes,
Don't
call
give
the
me, my
next
lord,
case.
that
Call the next. Application is dismissed. No, can 4 only. Yes.
My lord, should I wait for some time, my lord? At least.
No. Is dismissed. This is the way.
My lord, the operative part.
How it will be incorporated right now? What are you?
No, my lord, the
Call
operative
the list.
part of the order, my lord, at least that, my lord.
Call the list.
Operative part of the order is my right
30 and
to go through.
Item number 30.
Send it. He will add and then you send it for sign.
Or issue involved in item number 30 and 31, same and identical to the issues involved in 38, 40 and 41. Subject matter of challenge in item number 30 and 31 is the judgment and order dated 29th of February 2023. And
Send it for adding.
And in item number 38, 39.
Stipulate and send it.
And in item number.
Yes.
Item number 38, 40 and 41, subject matter of challenge in the same judgment and order delivered on 29th of February 2094. My lord, my humble prayer before my lord, let these two matters be tagged with the other two matters so that
you are for.
I am for the petitioner.
Petitioner.
Fine.
Only I have only one little submission. 5 minutes back, I got the affidavit. 5 minutes back.
What application has been filed?
This is an affidavit pertaining to my lord last order. Kindly see the last order. This is dated 12th of September 2025.
The vigilance report with the annexure. Lordship, I filed those.
And I find also that I am told by my learned juniors that the vigilance report has been brought on record pursuant to the directions of my lords. But my lord, the OMR sheets had not been annexed.
We'll see. They have just filed it. We will see.
I am just drawing to my lord's kind attention. I am not saying anything more.
The matter is the initiative. Matter is the ওনাদের ম্যাটার কি রেডি করেছেন?
না সেটা একটা কপি ব্যাপারটা তো একই
My lord, may I submit to one thing, my lord? Only 2 minutes I will take. This case has a checkered history. All the 25 original applications I have filed run at tribunal. All the 25 applications. I personally, I argued the case before the tribunal. In the reply before the tribunal, the Union of India did not disclose any document, only stated in some paragraphs that the cause of rejection is some and some.
Which matters? You are appearing in which matters?
38.
That's all. One case.
38, 40 and 41, same.
38, 40 and
41.
so you are appearing in those matters.
আপনি কোনটাতে appear করছেন?
No, and we're not in those three.
Who is for the respondent? In absence of respondent, how it can be taken up?
May I suggest one thing? Let these 3 matters be tagged with
Yeah,
2 matters 30, 31 and be taken up subject to
Have the affidavits been filed in those cases?
is everything. No, no. One day after vacation, any day after vacation, my lord.
No separate affidavit I do not find in my application.
There were no direct.
I only find an affidavit which has been served to me 10 minutes back.
That was pursuant to your lordship's order. We filed just the vigilance report was only annexed. That is.
But that report is not with him. Then if it is tagged, then he will not know what is going on. Therefore, but then you are not appearing.
Not appearing in.
Who is appearing in those matters?
Just come up.
না কেউ সেন্ট্রাল গভর্নমেন্টের
কি ছিল
সেন্ট্রাল গভর্নমেন্টের একটু রেকর্ডটা দেখলেই তো হয়
ছিল সেদিন আগে
স্যার একটু রেকর্ডটা যদি দেখান না
Let them all be listed together. What is to be done? And now it will come after the holidays. Cannot be considered because then the issue will be raised.
No, that is true. That is
whether
true.
the affidavits are there.
Given
Yes.
in one matter, another that will again lead to a judicial anomaly.
So give your appearance in 38, 40 and 41.
He can take the names and he can serve a notice.
Matters I am appearing for petition.
Union of India.
There is someone appearing for respondent. Respondent number 4 and 5 are represented by one Mr. Raman Bose.
Raman Bose, yes. He was on here on the other day.
Yes.
On the previous day, Mr. Raman Bose. was here.
So whoever it is, you give.
কোনো কিছু দরকার নেই
Raman Bose.
What is the case number of 38?
WBCT 169.
On one date, the learned DSG has also appeared. DSG has also appeared.
In 41.
169 of 24.
169. DSG.
Rupali.
DSG appeared.
Then as an abundant question, they submit one thing, subject to what falls for my lord's kind consideration. If my learned friend serves a notice upon the learned additional solicitor general, then perhaps the matter can be shortened.
No, but if somebody is already appearing, then he should serve on him only. 38, 40 and 41.
And Miller, only one thing, if in the meantime, after perusing the affidavit, because I have not perused the affidavit, if we feel that a reply should, an exception to this affidavit is required to be filed.
The learned
kindly
advocate
give
for the
that
writ
in the-
petitioner.
Seventeen. 17.
সারা আর একজন আছে একটু দেখে নিয়ে কোথায় নোটিশটা দিয়ে দেবেন হ্যাঁ
121.
But Milord, I have learnt it from my lords. There is no Milord, there is no hesitation in my mind to indicate to my lords that I have learned from my lords about this particular thing, that even if there is an irregularity, this can be cured in such a manner. And then after your lordship was giving a hint, then Milord, I searched the judgment, and my lord Mr. Justice Parthasarathy Chatterjee, while his lordship was sitting with my lord's Milord, also gave the reference of a judgment. And then I searched the other judgments which are prevailing in the field, and I got everything. This is something which I should say, Milord, I have learned from this court.
Yes.
Number 21.
My lord, in 21, my lord, Mr. Anirban Mitra is appearing on behalf of the Union of India, my lord. My lord, last occasion, he has filed the opposition, my lord. My lord, there was previous occasion, a direction was given to serve to the petitioner, my lord. My lord, he served, my lord, but unfortunately, my lord, the paper is lost, my lord, by his clerk, my lord. My lord, a date may be given, my lord, so he can serve again.
Nobody is appearing on behalf of the petitioner, then what is to be done? So you could not serve.
My lord, he served, my lord, but unfortunately, letter is lost by his clerk, my lord, actually. But he served, my lord. My lord, he can again serve, my lord.
Yes. Today is 3rd. The learned advocate for the respondent is
And 22.
May it please your lordship. Well, this is a matter your lordships have already heard. This is with regard to my lord availing of my temporary status. Second round of litigation. In first round, the tribunal has already held. They have complied. I don't need to open Lordship's records, everything.
Now,
My lord, Aparna Banerjee, advocate is appearing for the respondent.
There are only one request. Kindly keep it. Let the matter hardened part. I have to again argue. Well, kindly at least do this for the ends of justice. I do not stand in the way. Whatever fallen for an Lordship, I will follow. I will come after vacation. Kindly keeps in hardened part. Substantially hard part. Please, madam. Because I understand they would be
there
taking
was
time.
some, yes, I
My
know
lord,
because we have asked her to take instructions.
Yes,
Yeah.
again,
She
madam.
is saying that she has not got it.
Not yet got.
Therefore,
So, madam, kindly
Learned
keeps in hardened.
advocate.
One typographical clerical error. Lordship has possibly indicated, my lord. C 266.
2A.
2A. It possibly would not, my lord. Something say, my lord, it's 2005 and 2006.
2A.
Yes, but it's something, my lord, not 266. This is like this. Amar copy. Kindly give my copy, my lord. This page and the next page.
Oh, it's not 266, it's 2006.
Yes. As also 2005 also. Some.
But we have only noted 2000.
Very well, very well. So let
The
that
learned
corrections
advocate
be
at this
incorporated part
juncture,
of
the
that.
learned
And 24.
But may I take that?
It appears to be heavy.
I think 24. I think. আসেনি
না শরীর খারাপ Number 24, my lord, Mr. Sheikh Siddiqui Rahman, applying for the petitioner, my lord. So, lying in my lord. He has not come to court. I'm praying for, my lord, matter is the fix after vacation, my lord.
Appearing on behalf of the respondents.
As prayed on behalf.
Item 25.
My lord, this matter I beg to appear for the petitioner, my lord.
ওই কাগজগুলো কই? কাগজ বার করে রাখ। কোন কোন জায়গাটা দেখ, তুই খোল তাড়াতাড়ি।
My lord, agreed by the order dated, my lord, 9th of February 2023, my lord, passed by the, my lord, learned, my lord, Central Administrative Tribunal, my lord. The petitioner preferred the instant application, my lord.
प्रॉब्लम गंदा है पूरा नीचे। Put that right. Good. Okay. Okay, sure. चार पाँच 2016 में
What was the unfitness? What?
Lordship, unfitness diabetic. They found subsequently after 4 years of recruitment, my lord, they found the petitioner, my lord, diabetic, my lord. That is page 60, my lord.
When were you given the appointment?
Lordship,
When?
2012, your lordship.
Date?
My lord.
Well, September 22.
My lord, that is at page 47, my lord. Start from page 44, my lord, the provisional appointment, my lord.
Date?
Date is, my lord, 17th of April 2012.
17th of April.
Lordship.
And when you were offered the appointment?
Appointment offered on, my lord, Lordship, this provisional appointment letter was issued on 17th of April, your lordship. So far the date is concerned, your lordship, I am coming to that, your lordship.
And when it was cancelled by them?
It was cancelled, my lord, on by a letter dated 12th of October 2012, page 49, your lordship.
So there is 4 years gap.
From the date of the termination, from the date, your lordship, when this letter was issued in the year 2012, and when, my lord, the authority conducted the, my lord, the medical of the authority, when they find that the petitioner is suffering from diabetic. So there is.
You said that after 4 years after appointment it was cancelled. Therefore, we asked you the 2 dates.
Sir, lordship,
You said so. 4 years
lordship,
after the appointment.
Can
It's a
you
wrong
pardon me
fact.
for that, your lordship?
That is an incorrect fact.
Lordship. After 4 years, the petitioner was re-examined, your lordship. And the finding
He was appointed for the first time in 2012.
2012.
Before that, he was never appointed.
My lord.
And in 2012 itself, it has been cancelled. So where is the question of 4 years?
After 3 days, your lordship. 3 days, the petitioner worked.
1 day. 11/9/2012, you were given the appointment letter, and 12/9 it was cancelled. Next day.
But 3 days, they are also admitting that 3 days I have worked.
No, sir, it is 1 day. There is perhaps you have not gone through, or maybe we don't know.
So far, but
we have already seen in 2 minutes you are appearing. We don't know how you have not seen.
Page 49, my lord, is the letter where the.
So 1 day later they have done it.
My lord.
So that is immaterial. If you are not eligible, you are not eligible.
But my lord, there are reports, my lord. There are reports where, my lord, the petitioner.
So therefore, once they have conducted a medical examination,
my lord,
is it open to everybody to go and get reports from anywhere they want to say that no, I am fit? What is the law? Show us. Therefore, the facts are immaterial.
My lord. That appears from their own letter, page 47 once, my lord. Kindly have a look.
What is their letter?
Page 47, where, my lord, it is specifically mentioned that the authority declared the petitioner medically fit for the post by competent for the post, and he was medically examined by the competent medical authority. They are hereby posted a unit as indicated against each name. And, my lord, thereafter, my lord, they have appointed is purely provisional, subject to verification of school living certificate and caste certificate.
What occasioned the second medical examination? Why?
Lordship, after that letter dated 12th October 2012, your lordship, the petitioner, your lordship, produced the medical examination report by the CMO of Dumka, your lordship.
Therefore, we are asking you, is it open to everybody to go and get a report from anywhere and say that you rely on this? Why?
Your Lordship, they itself, they have written there that the content of the letter for bringing the medical report. May I read, Your Lordship? For
which medical report?
That the language of the letter wherein
Sir, the issue is once they have found you medically unfit, is it available? Is there an option given to the person that he will get a report from anywhere and say that you must rely on this? That is the only issue.
Milord. But Milord, here they have not said so, Your Lordship. They
No,
have
we are asking you. You have to satisfy us.
Milord,
Whether you can be allowed to rely upon a report from anywhere or it has to be done in the as per the procedure.
May I read the letter, Your Lordship, for
Which
medical
letter?
examination?
Which letter?
Page 49, Your Lordship. Letter dated 12th October 2012. Nowhere it is mentioned that the authority found the petitioner medically unfit. What they have stated, Your Lordship, that there is possibility of an error of judgment in the decision of the first medical authority. Possibility. They have not looked into, they have not gone into the, Your Lordship, the medical report. You may produce medical certificate in terms of para, Your Lordship, within 1 month from the date of receipt of this letter as evidence about the possibility of an error of judgment in the decision of first medical authority. This certificate will not be taken into consideration unless it contains a note by the medical practitioner. So, my lord, they itself, Your Lordship, ask the petitioner to bring the medical certificate with a provision that there must be indication of this letter.
Debatable. 522. Five two two. 522.
This is nothing. Prior to this, it is only provisional. No right has finalized in your favor.
And my lord, the page 46.
Is
the medical issued by the medical department, Your Lordship. This is the examination of fitness for appointment, Your Lordship, issued by the railway authority itself.
So according to you, once this has been issued at page 46, there is no scope for doing anything.
And my lord, thereafter, my lord, page 47, my lord, this is the certificate issued by the
What
same
is the
authority.
date of page 46?
46 is, my lord, dated 24th of, my lord, that is 24th of May 2012.
25th of May.
It is, my lord, in the top, my lord.
At the bottom, signature is of 25th.
25th, my lord. In the top, there is 24 signatures. 25th of May 2012, Your Lordship. Thereafter, another office order.
Obviously, what you are saying is once they have found you fit, there was no scope for doing anything.
No, my lord. I am not only that, my lord. The office order, my lord, they are issuing their order. They themselves challenging their order without any, my lord.
Challenging which order?
Which order, my lord? The office order, page, my lord, 47, Lordship.
So they are themselves challenging which order?
Page 47.
By page 47, they are challenging their
No, in page 47, they certify the petitioner medically fit.
By page
47, my lord. May I read, my lord? For
Please
myself,
read.
my lord.
Yes.
They have been declared medically fit.
Yes.
The second name is relates to the petitioner, Your Lordship.
Yes.
So this is the certificate by the same authority. After, my lord, 4 months.
When you were declared fit?
On 11th of September 2012. 11th September, my lord. Assistant Personnel Officer issued by Assistant Personnel Officer. Memo number is there, your lordship.
Where is the first medical report and what is the date? Show us.
My lord, what the authority handed over is, that is, my lord, page 46, my lord. 25th May 2012.
When we ask you, then you don't say we are asked. That is why we asked you. When you say that your medical fitness was already certified, it was certified by which authority?
My lord, subsequent to 12th October 2012, the petitioner, your lordship, approached the doctors twice, your lordship, and they also certify, your lordship.
We are asking you again and again. If you don't want to answer, then we will.
These are not made part, your lordship.
No. You are relying upon, you are saying that by page 47, they have challenged their own earlier decision. Now, which is the earlier decision challenged by them? When you were certified as medically fit? Show us. What is the date?
My lord, the medical reports are not available because that has been done.
So how do you know?
Lordship, the authority, my respectful submission is that, your lordship, page 47 is issued by the authority on the basis of some document, my lord. My lord, respectfully, I am submitting, my lord, page 47 is issued by the authority on the basis of some document, your lordship. They must have looked into the medical examination report of the petitioner, then they have issued this, my lord.
Examination.
And not only that, my lord, after 12th October 2012, my lord, the petitioner approached the authority with the physical fitness report and diagnosis, your lordship, done by the government hospital, your lordship, and submitted with the forwarding letter dated, your lordship, 30th of October 2012. Just after, your lordship, 18 days, your lordship, the authority did nothing, your lordship. So again, your lordship, the petitioner on, your lordship, 25th of January 2013, your lordship, submitted another medical report.
He says that he was medically examined on 12/2000. This is what he is claiming to be the fitness certificate. This is at page 46. Page 46. What is A2 category? Below A2 category?
Below A,
What is below A2 category?
below A2 category, trackman and
A2 category is a medical fitness category. What is A2 and below? Because this page 46 says you are A2 and below. So what is A2 and below? A2 and below can be appointed as trackman. Where you have said that A2 and below can be appointed as trackman.
So, Your Lordship, the notification itself, may Your Lordship go through it. Lord, for trackman, it's B1, Your Lordship.
So when you were certified A1, page 46 says A2 and below. So how you are saying that it was certifying your fitness?
Okay. Lord, then it's good for the candidature of the petitioner, Your Lordship, that Your Lordship, the cut-off marks for physical condition is B1, and the petitioner is, Your Lordship, having the better position, Your Lordship, A1.
Trackman is a very sensitive job. It involves safety of the train. Anyone below the medical category cannot be appointed. You are admitting that the required category is A1. You are in A2 and below. So what case you have? You are harping and relying on page 46. Page 46 says you are A2 and below. Then how you can get? That's why we are asking you.
That post is for B1, Your Lordship.
And you are required A1 for trackman.
No, required B1, Your Lordship.
So that is also above A2.
Required. No, B1 is may I go through this? Then I will come back, Your Lordship, with this category.
Where is it? Is it on record?
My Lordship, it is not. Only at the accommodation for the day, Your Lordship, I will come back with proper instruction.
What is the issue?
My Lord, issue is rightly my Lord has pointed out. My Lord, he has, when he has been found below category.
What is the category, requisite category for trackman? Where is it?
Well, my Lord, we have the memorandum, my Lord, that is vision tests required for the interest of the public safety. Just now, my Lord has stated that is 510 clause. It says accordingly it has to be done. Now, my Lord, the issue remains when he has been found the below rank, he opted for the other post before the authority, as there is a memo issued by the authority in the year 2009. For such reason, he has tried to put himself in other category so that he can get the appointment.
Any job for A2 and below category, he is willing to go for that.
Go for that.
Or opted for that.
Yes, opted for that. Now, my Lord, according to the memo issued by the authority, that is at page 104. That is, my Lord, page 104. My Lord has got it. 104. 104, the memo by the strength of which, my Lord, he is trying to get the appointment for the other category, my Lord, that has been recalled. Or, my Lord, withdrawn, my Lord, that will not be given effect to. That is the problem. And it has been issued on 3rd September, and my lord, the order of appointment 11th September and 13th September, my lord, we have. That is the main memorandum, and the earlier memorandum, my lord, that is he is relying upon, that is 1st June 2009, that is at page 102. That is the main issue before your lordship. Now, when it is not there, then my lord, we cannot provide the.
We are still looking for where is the categorization.
The categorization, my lord, if your lordship wants, my lord, I can give it, my lord.
It's
They
not
have
on.
considered others, your lordship, those who are not found. It 106 page, your lordship, there are list of candidates who were accommodated in.
So two wrongs will make a right.
No, my lord, that was, my lord, they have been appointed, my lord, prior to the 2012.
2012,
Oh, they have considered for alternate.
Alternate.
How they can consider after
That is,
this?
my lord, that memorandum has already been recorded.
That memorandum was issued, your lordship, subsequent to the notification, your lordship. On that ground, they have, your lordship, considered others.
Yes, my lord. No, Kunta. 2009 memo, when this was published, my lord, that appointment was given prior to the issuance of 2012 memo.
That was given after this recruitment process, considering that the notification was issued prior to implementation of the memo.
No. কোনটা তোমার পেজ বলো কোনটা 106
হ্যাঁ 106 টা চাকরি
না
পেয়েছে আছে ডকুমেন্ট
কোথায় 106
106
yes they have been given appointment 21st July 2012 or this memo has come on 1st September 2012 just now I have indicated before the court after that for such reason we
And where is the advertisement?
that is P1, your lordship.
That he can argue.
Lord, page 38.
That if the process has been initiated.
Page 38, my lord.
The basis of.
not only that, my lord, initially, my lord and friend has already approached this court. The tribunal has directed to reconsider his case sympathetically, and it was
no, my lord. That application was filed for a direction upon the authority to conduct medical examination.
What he's trying to argue is that the recruitment process has.
And it was examined. He was examined.
নোটিফিকেশনটা রেফারেন্স দেবেন বা কপিটা পাবো ওই যেটা কোর্টকে দিলেন
তো 510 ওই তোমাদের লিখে দেওয়া আছে দেখো ওই ওয়েবসাইটে গেলে পেয়ে
So you want to argue that this policy will not affect you because your notification is much prior to this.
And my lord, that is not retrospective effect, my lord.
So that you want to argue. That he can argue. That has been that you have argued that before the tribunal.
No. That point has been ventilated before the tribunal.
No. नहीं reasoning है नहीं.
And another, my lord, thing is that, my lord, 2002 letter was issued for re-medical examination. 2012, the authority did nothing, your lordship. The petitioner repeatedly approached, and under compelling circumstances, your lordship, bring the medical examination report from Dumka, Jharkhand, submitted before the authority. They have not considered. Lastly, your lordship, the petitioner approached before the Central Administrative Tribunal. The learned tribunal, your lordship, directed the authority to consider the case of the petitioner within 2 months. They did nothing. Thereafter, the petitioner repeatedly approached after 7 or 8 months. There is a gap of 4 years, your lordship, from the date of the letter for re-medical examination and the date when the re-medical examination was conducted. So physically, your lordship, the human bodies are, your lordship, changing, your lordship. There may be, due to these changes, your lordship, they found diabetic, your lordship.
No, they have already placed you
4 years, your lordship.
A2 below category. You have already been placed
A2
in
below category, your
in
lordship.
2012 itself.
With that, your lordship, I will come back. A2 vision.
ভিশনের জন্য আর ট্র্যাকম্যানের মেন হচ্ছে ভিশন সিগন্যাল দেখতে হবে
But I am also praying for a direction upon the authority to consider for C1
No,
category,
if
your
that
lordship.
if you want to argue that issue, you have to argue with some judgments.
Lordship.
You can consider that argument.
My lord.
It is submitted by the learner.
डेट में kindly refuse, my lord. 10th November. Extremely. I'm grateful.
26.
So I am applying for application.
Whether performed service can be considered in other service. You are the applicant.
Lordship.
So being a uniform service, you want to be considered in the civil cadre.
Because the application, when the advertisement was made, there was no segregation. We have made application and they
When the segregation came into existence.
Lordship, segregation has been came after written test was held.
Give the date, sir.
Lordship, date is 6th May 2016.
Prior to that, there was nothing.
There was only written test was held.
Oh, no, no.
No, there was no segregation. The RPF will
6/5/16 segregation has come into existence. Where is that?
5/6. Lordship, page 75.
Page 75. And what is the date of the advertisement?
Lordship, advertisement date is 21st August 2015.
My lord, I'm praying for not this week. Kindly take this matter after vacation.
27.
I'm appearing for the Union of India, my lord.
My lord, Mr. Bodhisattva বিশ্বাস appearing on behalf of respondent number 226. He is very ill due to his high fever. Therefore, he is not to come today. My lord, being for after vacation.
On grounds of illness of who are respondents 4 to 6? Who are they? Respondents 4 to 6?
As per instruction of our reply,
Very nice. Very nice. Very good. This is how you will make submission to a court. Whatever a clerk tells you in your ear, you will tell it to the court without knowing whether it is factually correct or incorrect. You should know better. You should know better. Don't do this. 2 and 3.
And 28.
I am appearing for the Public Service Commission. It is the matter where Lordship they have annexed the answer sheets of two other candidates.
My lord, Mr. Fidos, I am appearing on behalf of the petitioner. He is in code number 11 on his legs. Kindly make it not today, my lord.
Not today.
Grateful, my lord.
Grateful, my
As prayed by learned
And 29.
I am for the respondent.
Cannot join 1975, my lord, as Tahsildar. After that, my lord, the Tahsildar post was abolished. And 1975, 1984, he appointed as Bhumishayak. That post was abolished and Bhumishayak came. And 84 to 96, my lord, he worked as Bhumishayak. And in 1996, trace examination, he was appeared and my lord got appointment as revenue inspector in 1996. But in 2001, my lord, one memo came and we came to know in 2008 that my client, my lord, promoted as Bhumishayak grade 1 in 1987.
application in 2017.
I will kindly see page 42, my lord. Where my lord, District Land and Land Reforms Officer in 2013, my lord, memo dated 13/1/2008. He wrote a letter to the Director of Land Records, my lord. Previously, Sri Noskor has filed an application to inclusion his name in the respective gradation list and consideration for promotion. On the basis of the said application, his name has been included in the gradation list communicated via the memo number such and such. Next paragraph. Now, on examination of the office records, it transpires that Sri Noskor is entitled to get his promotion as grade 1 PS, that is Bhumishayok, with effect from 1/7/1987, as his junior colleague Sri Kumar Mondal got his promotion with effect from 1/7/87 as grade 1. I then only 1/7/87 to 1986. I got promotion as grade 1 BS. That is why, my lord, I am entitled to get, my lord, promotional benefit as my junior.
What is BS? What is BS?
Bhumishayok.
You are relying on page 42. If his junior has got it, why he will not get promotion, my lord, with effect from 1987? My lord, so far this Balaram Noskar is concerned, my lord, when he was appointed as revenue inspector, that, my lord, I have to take instruction because this Arun Kumar Mandal must be similar as him, Kumar Mandal, because he is junior to him. So if it has been granted to him, then why not? My lord, here, my lord, the petitioner, if your lordship kindly consider page 17. His prayer is, my lord, the differential pay, my lord, for the period from 87 to 96 as Bhumi Sahayak. So therefore, if his junior has been granted pay, then whether he should be granted or not, whether if his junior has been granted just seniority or just counting of the service or something like that, then whether he should get the same or not, that is the issue. Whatever his junior has got, if, my lord, any financial benefit was given, or, my lord, if Balaram Noskar is similarly situated with the petitioner, my lord, then
petitioner.
yes, Mandal, Kumar Mandal.
Balaram Kumar Mondal, yes.
Sri Kumar Mandal.
Sri Kumar, yes. My lord, if Sri Kumar Noskar, my lord,
If he has got a benefit and he is junior to him,
then he is entitled.
then he may be in a position to claim that. So you
Give me 2 days time, I can take instruction. Clearly stated that Sri Kumar Mondal
Let him find out. Let him find out. The learned advocate